Good morning, everyone. Welcome to the next lecture on Criminal Procedure Code. In this lecture, we'll be talking about the trial process under CRPC. So, what is a trial in the first place from the definition aspect, along with the procedure being followed in a trial and various types of trial will be discussed in this lecture. A small recapitulation or revision of what we have done in the previous class or previous lecture. We have done an understanding of the process of investigation. So what is the investigation process? Understanding of the steps required in an investigation process and the authorities involved in the investigation process has been done in the previous lectures. Next is we have done an understanding of the process of inquiry. Again, the steps of inquiry, the authorities involved, and what is exactly the procedure of an inquiry process has been done in the previous class. And lastly, we have done an understanding of the differences between investigation and inquiry. So there are 4 points of difference we have done in the previous lectures in relation to differentiating the process of investigation and inquiry. The object of the present lecture, okay, which we want to achieve is understanding the trial process under CRPC. So what exactly is the trial process? Second objective which we want to achieve is understanding different types of trial. So there are different types of trial given under separate chapters of CRPC. What are those different trials? How you will be determining whether this trial will be followed in this kind of case, and what is the exact procedure being followed, we'll be discussing in brief. Next is understanding the difference between investigation, inquiry, trial. So we have done the difference between investigation and inquiry. Now we will be making a differentiation of investigation inquiry with the trial in detail to understand the difference between these three concepts or these three processes. Coming to the introduction, to understand trial, we have to understand the basic concept of on what basis a trial has been done. A trial is a process in which two parties are in dispute. So like in a civil case, there is a civil dispute. In a criminal case, there is a criminal dispute, where there are two parties. One is a defendant, the other one is an accused. And it is a determination by a judge or a jury, because jury system used to be followed previously in India as well as in some other common law countries. Now it is no more. So it is a determination by a judge or a jury whether the accused person is guilty or not. A trial happens when it is pleaded by the accused person that he is not guilty. Under Indian law, CRPC or Criminal Procedure Code states that there are 4 types of criminal trial, namely session trial, warrant trial, summon trial, and summary trial. These trials have been further bifurcated under different categories. Being under a common head of criminal trial, we tend to forget that these are 4 distinct types of trial with different and dynamic processes involved in each and every trial. In the following article and the following lectures, the concept of summon trial, warrant trial is discussed in detail, particularly dealing with the distinction between summon trial and warrant trial. Coming to the concept of trial, the Code of Criminal Procedure does not define the term trial. So unlike inquiry and investigation, there is no clear definition of the word trial, or there is no specific section under which trial has been defined under CRPC. A trial is a judicial proceeding that ends in either conviction or acquittal of the accused but not discharge. Discharge normally occurs before charge framing. If charges has been framed, court will be deciding whether the person is guilty or not guilty. If he is guilty, he will be convicted by the court. If he is not guilty, he will be acquitted by the court. So that is the actual conclusion of a trial. Now, trial is an examination and determination by a judicial tribunal over cause on which the court has jurisdiction. So, the actual appreciation of evidences of the whole case by a court or a judicial tribunal who has jurisdiction over the matter will be conducting a trial for that case. The trial begins in a warrant case with framing of charges when the accused is called to plead before the court, whether the accused wants to plead guilty or not guilty. In a summons case, it is not necessary to frame formal charges. So, the initial point, the starting point of a trial in a summons case has to be determined on informal framing of charges. There is no proper framing of charges. The trial starts as soon as the accused is brought before the magistrate and the particulars of the offence are stated before him. The case which is exclusively triable by court of session, there the trial begins only after committal of the case. We will be discussing in brief the concept of committal. And appeal and revisions are certain terms in a trial, okay, where after the initial trial has been conducted, these are post-trial processes. So there are different types of trial and different stages of trial as well. The basic feature of a trial, if we go to the little meaning of the word trial, it is an attempt by the court. The basic purpose is examination of by a test. They will be examining different evidences and the judicial examination and investigation. Don't go by the word investigation. Investigation as in the court is trying to investigate as to whether the accused, based on the evidences produced before him, has committed an offence or not. The meaning of a trial in simple words is a judicial proceeding conducted by a court, specifically in a criminal case, because in a civil case we do not use the word trial, we use the word civil proceedings. So these are criminal judicial proceedings conducted by a court. The commencement of a trial normally is after submission of a challan, okay, or submission of a charge or framing of a charge till the announcement of judgment. So from the point of framing of charges till the pronouncement of actual judgment or till the pronouncement of actual sentence to be given to the accused, the trial continues. The end of a trial normally results in either acquittal of the accused or conviction of the accused. So the accused is either guilty as has been decided by the court, or the accused is not guilty will be the end of the trial. Different procedures of trial under CRPC. So there is a trial by magistrate, there is a summary trial, there is a trial by high court or court of session, and different types of trial which will be dealing in detail in the coming slides. The types of trial as per CRPC are mainly divided into three parts. So there is a trial by court of session, which in other terms we use under CRPC as court of session trial. Second is trial by a magistrate. So for court of session trial there is a separate chapter. Court of session trial normally starts after committal of a case. To understand in brief what is committal of a case, the initial process will be followed by the magistrate before the charge framing, after verification of all the documents. Now the court does not have the power to try this case. The magistrate does not have the power to try this case. Initial steps has been taken by the magistrate. The further step required in this case, okay, the magistrate will be forwarding the whole case along with the accused with all the documents and with all the case files to the higher court, that is court of session. So this transfer of case from lower court to higher court for the purpose of conducting an actual trial is done, okay, where the court of session trial actually begins. This is known as committal, the transfer of the case. Second type of trial is done by a magistrate. So a trial, actual trial, okay, done after charge framing by the magistrate, a judicial magistrate first class, a judicial magistrate second class, and additional chief judicial magistrate. an additional chief metropolitan magistrate, a chief judicial magistrate, a chief metropolitan magistrate. All these judges, when they are conducting a trial, which is not a court of session. Court of session is technically a court of appeal as well, are trial by a magistrate. Now these are further bifurcated under different chapters. So a trial by a magistrate can be a warrant trial on a police report. So first of all, it is a warrant trial, a trial of a warrant case. What is a warrant case? Where the offense has been punishable by more than 2 years. And this warrant trial is based on a police report. It means there was an FIR filed in this offense, which is punishable by more than 2 years. The police officer conducted an investigation, and on the basis of this investigation, the police officer submitted a police report. So warrant trial on police report. Second is warrant trial otherwise than on police report. So this is also a warrant trial where the offense is punishable by more than 2 years. But there is no police report. Then on what basis this case is going on? So you can, in other terms, you can understand it as warrant trial based on a complaint or an information, not on a police report. Instead of filing an FIR, you directly filed a complaint before a magistrate. So warrant trial on complaint or information. Next, another trial which is conducted by a magistrate is a summons trial. A trial in a summons case. To understand this, you have to understand what is a summons case. So a case which is not a warrant case is a summons case. It means a case where the offense is punishable by 2 years or less is a summons case, and the trial being conducted in a summons case is a summons trial. The basic difference between a warrant trial and a summons trial is, in a warrant trial, normally formal framing of charges are done. So court will be conducting a hearing of charge, and the court will be taking formal framing of charges. In a summons trial, court just states to the accused what offense, what allegations of offense has been laid against him, and on that basis court will be proceeding ahead with the summons trial. So summons trial, as these are for less grave offenses, okay, so this is a comparatively simpler procedure as opposed to a warrant trial where the degree of offense is higher, and that is why the procedure is also comparatively strict, and that is why there is a proper formal framing of charges. Last one is a summary trial. As the word suggests, summary, in a short manner. So summary trial is a short manner trial. Summary trial has been given in a separate chapter of CRPC. Normally in a summary trial, the procedure of summary trial itself is followed, apart from certain complicated recording of evidences which can be done on affidavit. The judgment in itself can be written in a small format, and there are specific cases, very less, even less grave than summons trial. Offense is punishable for theft of property up to 2,000, or which are punishable only by 6 months. There are certain cases where the state government also decides whether this case can be tried summarily. One prime example of this is the case of 138 negotiable instrument, that is check bouncing cases. There can be a summary trial, short manner trial, brief trial, because the offense is not that grave. These are different types of trial. Now coming to the difference. Now this is the most important aspect, because we will be dealing with the difference of inquiry, investigation and trial, all the aspects. And understand this with the video as well. The trial by whom conducted? Normally it is conducted by a court. So a trial is never conducted by a police officer, it is always conducted by a court. Secondly, it always ends in acquittal or conviction. So from this aspect, try to understand the difference between inquiry, investigation and trial. In terms of conducting authority, inquiry is done by a magistrate or court. investigation is done by a police officer or any person, private person even, authorized by a magistrate. And trial is done by a judge or a magistrate. You can call it a court. So in terms of conducting authority, inquiry and trial are conducted by magistrate, court, judge, whatever term you want to use. So inquiry and trial are conducted by the same authority. Whereas investigation is conducted by a different authority, that is a police officer, and in certain cases a private person. Commencement of the case inquiry, it starts when the a complaint has been filed by the magistrate. Investigation, when it comes, the actual stage starts with the filing of or lodging of FIR, and in certain cases by a complaint where the magistrate orders an investigation. In trial, it starts either by framing of charges or by arraignment of the accused. So the stage of commencement of inquiry is normally after the complaint has been filed, and in certain cases after the submission of police report. Investigation is when the FIR has been filed or lodged, and trial when the framing of charges has been done by the court. As to its meaning, inquiry is any proceeding conducted by a magistrate or court. Investigation is a proceeding conducted by a police officer. So they are different authorities and these are different proceedings. The actual steps involved are also different. And trial is the final step where the judicial proceeding is conducted by a court. So in investigation and in trial, the conducting authority and the judicial proceedings are done by a court. But the proceeding in itself in inquiry and trial are different. These are both judicial inquiries, judicial proceedings done by court, but the steps involved are very different. Next point of difference is the result. Now, inquiry, when it finishes, are only giving you recommendations as to whether the court should proceed ahead with the case or not, whether the court should take further step or not. This step can be charge framing. This step can be issue of process to the accused, issuing summons and warrants to the accused. So based on the result of inquiry, the court is only trying to find out whether the court should proceed ahead with the case or not. The result of the result of investigation is when it finishes with the result, but with the opinion of the police officer. The police officer submits this opinion of the investigation process and the conclusion of the investigation process in the form of a police report to the court. So the final result of investigation is a police report. This can be a positive police report where the police officer says that the accused is guilty, or it can be a negative police report where the police officer says that the accused is not guilty. And the final result of a trial is either conviction and giving proper punishment or sentence to the accused, or acquittal. The further differences between investigation, inquiry and trial can be understood from the purpose of these proceedings. The purpose of inquiry is determination of truth to proceed ahead with the case, whereas the purpose of investigation is collection of evidences to reach to the near truth. Trial is completely different. Trial is whatever evidences you have collected from the investigation, whatever determination you have done from the inquiry, the finalization of that truth or falsity to determine whether the person is guilty or not is the ultimate purpose of a trial. For proceedings, inquiry is a proceeding by a magistrate, investigation is a proceeding by a police officer, and trial is a judicial proceeding again by a magistrate or a court. The framing of charges, inquiry in a charge, normally at the stage of inquiry there is no framing of charge. At the end of the inquiry, the charges are framed. Investigation is not for the purpose of framing of charges, so there is no framing of charges in investigation. And trial actually starts with the framing of charges. So after the inquiry is over, okay, at the last stage there will be framing of charge and then the trial starts. The remedy of an inquiry normally is an appeal or a revision against the decision. Against investigation, there can be a second order for inquiry or a re-investigation, or the court can take the whole matter of investigation into his own hand to conduct an inquiry. The remedy for trial is transfer, okay, of the whole case. It can be a revision, it can be an appeal, it can be a review as well. The process of an inquiry, normally inquiry, okay, is the second process. Investigation is the first process and trial normally is the last process in the whole proceedings of investigation, inquiry and trial. For reference purposes, to understand the same, you can refer to indiaqanun.org, the respective link I have shared. The article on prosecution of criminal cases in court by the complainant under section 2. This is also a relevant article to understand the differences. And you can refer to the Code of Criminal Procedure by Justice Y.V. Chandrachud and V.R. Mohan. And you can refer to Ratanlal and Dheeraj as well to understand these concepts in detail. Thank you everyone.